Hey everyone, Chris Haddon here with the Hard Money Mastermind with a very, very cool expert interview. Today we have Kimberly Mann, attorney Kimberly Mann from Shulman Rogers here in the DC area. We're going to be talking about all things capital. Kim, thank you for being with us.
Happy to be here, Chris. Thanks for inviting me.
Sure thing. No, I appreciate it. As we get started here, if you wouldn't mind, could you give a little background on yourself and your professional history and what you focus on as an attorney?
Sure. So I am a funds lawyer. My practice is principally the formation of funds, all kinds of funds, real estate funds, private equity funds, venture funds, and other alternative funds. Been doing that for about 24 or so years. I am currently at Shulman Rogers. I co-lead the funds practice there. I also represent from time to time institutional investors and other investors in funds and co-investments.
Very cool. Yeah. In case people haven't heard us mention this before, we've been a client of the firm Shulman Rogers for many years, probably over a decade, for a number of different things, anything from our default related loan work to operating agreements, other sort of investor agreements. So yeah, we've had a long and prosperous relationship with the firm.
Yeah, very good.
Yeah, it has been very good. Okay, let's dive right in. So the reason why this is such an important topic to our group of hard money lenders, private lenders, aspiring folks who want to do that is that not everyone is clear on the different ways that they can possibly structure their capital. And I think that could vary based on a number of things. One of them just being size. So I want to talk about the fund structures first, I'm not an expert in this stuff, but I'm going to throw out some terms. Feel free to correct me in any way.
Sure.
But the ones that we've been aware of over the years, like Reg D forever. And then later on, there was Reg C that came out after the financial crash and all that. I know that some larger lenders, especially focusing on bigger commercial stuff, private lenders, will often make sense for them to do a fund, in terms of just the cost of it and the different kind of accounting and stuff that goes into that. But as you get smaller, it kind of makes less financial sense. And there might be some other structures there are pros and cons, and we're going to talk about the business pros and cons and legal considerations as well. But if you wouldn't mind, could you just dive into a bit of what the setup looks like if somebody were to raise a fund in order to lend out money?
Sure. So, funds come in all sizes. So there are small funds, medium-sized funds, and large funds. Funds do tend on the front end to be expensive to set up. And so people frequently shy away from funds because of the cost aspect and the perceived difficulty in administering them. But if an issuer or sponsor is going to think long term, a fund might be a good way to go. So, as you indicated, there are some regulatory issues to consider in connection with a fund, but the principal benefit, in my view, of a fund is that you've got readily accessible capital there. So even if you're, a couple of $1 million, you've got that pool of capital that you can deploy. You don't have to keep chasing money. You've got some period of time with which to deploy that money. And so it often makes sense to do a fund. But if you're going to do a fund, whether it's a big fund or a small fund, you do have to be cautious of the cost incurred, and there definitely are costs related to it. But over the long haul, it could make sense even if you're just raising a few $1 million.
Okay. And could a fund be open-ended? So it's not the kind of thing that you would have to close and redo in 5 years? Could it be a perpetual sort of thing?
It could be, and those are called evergreen funds,
Okay.
Meaning that they are perpetual, they go on forever. The question is, how do you exit that fund as an investor? And as a sponsor, how do you allow for exits? And if you're a real estate fund, those exits can be difficult because it's a long-term investment for the fund. It's real estate, it's not liquid. So a sponsor will have to figure out on the front end how to create liquidity for the investors in the fund if it's an evergreen fund. But the concept is that it goes on forever. You can exit by selling your interest or being redeemed out of the fund, and then new investors just keep continually coming on quarterly, monthly, all the time. Just depends on how that fund is set up.
Yeah, redemptions is definitely a common word that you hear in financial news related to private equity and hedge funds. And something goes wrong, people want their money back, and it
That's
could
right.
cause, potentially a problem. Maybe not in a lending company as much, but in certain setups where people do have to return capital unexpectedly.
Right. That's right.
Okay. If you could talk a little bit about the different types of funds, the most common used funds, and what the documentation is that goes into the structure and organization of that.
Sure. So even though so-called 506c funds have really become popular, 506b funds are still the most commonly used funds. And those are the funds that do not permit general advertising or general solicitation, meaning you can't go out in the newspaper, on the news, on YouTube, and advertise your fund while you're raising money for that fund. 506c, on the other hand, does permit general advertising, so you can shout it from the rooftops if you want to, but you can only have as investors accredited investors. So they have to meet the definition of accredited investor in order to qualify to invest in a 506c fund. A 506b fund can have up to 35 non-accredited investors.
Oh, that's good to know. Okay. Yeah, I'm not an expert in these distinctions, but that could definitely be applicable to our members. What are the documents created that people would show to an investor besides their pitch deck? Obviously, we know that part, but the documents that people would have to sign in order to commit.
Right. So sometimes there is a offering memorandum. We always recommend an offering memorandum, even if it's a very small fund. An offering memorandum not only helps to clarify the terms of the fund and reduce the risk, but an offering memorandum also is required by some investors. So let's say you've got an institution or a family office. They may have a policy that says they won't invest unless there are certain documents that are provided, and an offering memorandum may be one of them. So the offering memorandum consists of the business case. It talks about the management team. It talks about the terms of the fund and the risks. It talks about conflicts of interest and other things that are pertinent to the fund. If there have been deals already put into the fund, it will talk about those deals. The second document would be the actual partnership agreement, if it's a partnership, or operating agreement, if it's a limited liability company. Really talk the details of how the fund operates, how you exit, how new members are admitted to the fund, who votes on what the voting thresholds are, how the waterfall works, how distributions are made, when they're made, how allocations are made. So that's the second document. The third document is the subscription agreement itself, where the investor actually makes the commitment to the fund.
Okay. So when investing in a type of fund like this, they are actually owning a percentage based on how much they invest of a business entity set up for this purpose.
Right.
That's typically
correct.
how it goes?
That's right. That's right. So there might be a minimum investment amount, but each investor has a commitment, and then there's an aggregate commitment, and your ownership stake is your percentage of the total commitments to the fund. Got it.
And once someone commits to the fund, selects an amount that they're going to invest, signs all the agreements, puts their money into the fund. After that, is it all up to the sponsor? They do their business without necessarily consulting the investors? Is there any additional investment approvals required?
Depends on the fund. And let's talk a little bit about how money is put in, because sometimes a fund will have the money all put in at once, and then others have installments. Capital calls will be made and money will be contributed over time. That's usually driven by the deal flow and the need for cash.
Yeah, that makes sense.
Yeah. So with respect to voting rights, some funds are more democratic than others. Sometimes it's rarely the case that investors get to vote on the actual investments that the fund will make. There are funds where there's participation by certain investors on the investment committee, but for the most part, the sponsor makes the decisions about that. And voting rights also depend on the fund. Sometimes, particularly in retail funds, there are very few voting rights for investors, and then for other funds, there's more voting rights. So it just depends.
Yeah, that was always an interesting part of the debate. So for everyone watching, just to give a little background in case they haven't heard us talk about these pros and cons, I'm going to jump in on some of the business considerations as Kim's discussing the legal considerations. And one of them, when we were getting started, when we started our hard money lending company, it was the very end of 2007. And things had just crashed and was crashing at the time in real estate and the financial world. It was during Madoff time. So a lot of the people that we were approaching about investing in our loans with us, they were very nervous about many things. The value of real estate itself, fund related. There's all kinds of bad, in case people weren't around during that time or weren't active, there was all kinds of bad stuff going on. And the people that we spoke to, these are savvy investors who are with us, and they still are. They were very wary of doing a fund because they saw it as lack of transparency once the money went in. Right. And that we would get to roll, with our loan underwriting and deal funding as we saw fit. And because of that, because we were raising capital during such a difficult time, people were more nervous than they are now. People are bullish about a lot of stuff. You can just see everything skyrocketing in all kinds of different markets. So our investors, and like I said, a lot of them are savvy. They wanted to see the deals. They wanted to approve deal to deal. And so we're going to transition into this next sort of capital raising structure now. The reason why we did this partially was because that's just what our investors wanted. And now there's pros and cons to doing it this way, which I'm going to describe now. Like we refer to this setup, and it's pretty unique, I think, to lending. Like we'll call it the direct placement model or co-lending, or in the past it was called trust deed investing, stuff like that. And here's the way it works in case people aren't familiar. In the states where we do business, where we lend, anybody can be a commercial lender. There isn't a license out there. So our company can be one. I can be one as an individual. My Uncle Norman can be a commercial lender. It might not be that way in all states, like California, for example. But so the way it's set up is that currently we have, and it's been the same people for a long time, maybe 75, 80, 85 individuals who have a lender account along with us. So like our entities will have one, individually we'll have lender accounts. We're basically a friends and family fund, and we all lend alongside each other. Now there's more back and forth between, so every day I'm looking at the cash that we have in our escrow account in everyone's funds, and I'm communicating constantly with our capital investors about, hey, I'm putting your funds into this deal. And so there's more back and forth that you might not have with a fund setup. But at the beginning, that transparency and co-underwriting with them was very, very important to our people. Now they don't really care. It's been 12, 13 years, and they're just like, that deal looks great, go for it. But that was kind of the pros and cons between It's creating more work on our end, but at the same time, if the investors are happy, that's super important too. That's right. Yeah. And, the situation that you described in 2007 is a good example of where people want to be more hands-on and where your model might work better. In times like these, a fund may work better because you don't want that back and forth. You want to take the money and go with it, because who would know better than you, how you should deploy that money, and perhaps your time is better spent rather than going back and forth, just doing what you do. So there's certainly pros and cons to both ways. There are. And I would even consider doing a fund, like if I were restarting our company today, I might do exactly that, depending on the resources that we had and everything else. And so we basically chose our setup out of necessity and just stuck with it. Right. And it works. I mean, it works. Those people that are using your model right now, your investors,
might be prime candidates should you want to start a fund. Those could be your go-to people. And there's certainly nothing to say that you can't have a fund and a co-invest model or a direct invest model.
Okay. Yeah, that's a good point as well. That's a good point as well.
Side by side.
And also, luckily, the industry software that we use that people have heard us mention before is set up for either model. So in terms of the accounting part of it, like there's a fund module if you want to have that, and it'll be very clean and organized in that way, and the proper reporting at the end of the year. Or in like the co-lending model, it does that very well as well. So just something else to throw out there related to the accounting, because a lot of people would think like, oh, I wouldn't know how to do the math on a fund. There are solutions out there for it.
Right. Yeah.
And also, and people have asked before, and this is something that we've worked with Shulman on in the past, the documentation that goes into a relationship like that, different than the subscription agreement and the operating agreement and all of that, is more straightforward, but just important. Like I think the document that was created for us is called a lending and servicing agreement. And it basically just outlines who's responsible for what between us, the lending company, and the capital investor. And with that, besides the actual loan documents per deal, that would be the most important agreement in a setup like that, right?
That's right. That's right. Understanding who's responsible for what, who's in control, how the money is funded. Very, very important.
Okay,
very
got it. One more setup that I want to touch on, because I know that some lenders have done this one in the past. Not too many. I don't think it's the best option, but sometimes lending companies like ours would actually borrow money just using an unsecured note from their investors. And I don't know exactly, they would say, okay, we're going to pay you 10%, interest only payments made monthly for a term of 5 years or whatever it may be. And then they would use the money to lend out. I don't love it business-wise, because you're going to owe money even if you have downtime and you have a lot of cash in your account. You're still going to be responsible for servicing that debt. Do you see any issues with it legally?
So, it may not be obvious, it may not be intuitive, but a note is also a security. And what some people don't tend to think about is what securities regulations, laws might apply to those transactions. A note that a borrower would issue in that circumstance is a security. And so the Securities Act would apply to that. You have to look at how you're soliciting, you have to look at who your investors are, what disclosure, if any, you're giving. So those are things to consider, even in a structure like that.
Yeah, I hadn't thought about that in a while, but I had been told that in the past. In addition, there's some gray area related to our direct placement, our co-lending model, that could be seen as selling securities as well.
That's
even
right.
though we don't advertise and we're basically friends and family and associates and the same people for a long time, the argument could be made that we're selling securities by allowing people to lend with us.
That's right. That's right. And the Securities and Exchange Commission and the state commissioners, the state securities commissioners, like to think that most things are securities.
Mm-hmm.
So the default is that it is a security. One of the things that you look at is the control and the participation. Are you doing all the work? Are the profits being made solely from your efforts? What voting rights do your investors have? Those are the things that you look at to determine whether something is a security.
What sort of scenarios might the state or the federal government step in to have to even address this? I'm guessing if it's somebody loses money and then they go.
That's right.
I'm sure it starts with that.
That's right. If the deal goes south, then that might happen. If the deal does not go south, it's unlikely that somebody's going to complain. But it's in certain circumstances where people lose a lot of money or are somehow disgruntled, feel slighted or cheated, then they might report. And then the commission or a commissioner might come in and look. Highly unlikely in most cases, but it could happen.
Yeah, just reason number 1,000 and 1,1200 to do good deals.
That's right. That's right.
Excellent. All right. Yeah, I think that is the majority of the questions that I have. I'm looking at my notes right now. The three main sort of structures that I am aware of for a lending company like ours. Is there anything I missed? Is there any?
One thing to think about too, in the context of a security, is whether the sponsor is acting as an advisor to the fund. Meaning, is the sponsor actually recommending or advising on the purchase or sale or holding of a security? If it is, then you have to look for an exemption under the Advisors Act, and that's something that people sometimes miss. So something to consider if you're sourcing transactions, if you are making recommendations about securities, then you really have to think about the Advisors Act and whether you're required to register as an investment advisor.
That's an interesting point, because if you break it down, that's in essence what any sponsor sourcing a deal is doing.
Right.
I mean, there's no deal unless we source one and underwrite it and say it's good.
And say it's good, right. And so at that point, you look for an exemption.
Okay.
Yeah. So something to think about.
No, for sure. I mean, there's definitely a number of different considerations here in legal aspects and business aspects. Anything else that you might mention that people should be aware of or make sure to speak to an attorney about before they start raising capital?
I think it's always a good idea. I'm selling my own book here, but it is always a good idea to consult with an attorney before you go out to raise money, before you send out marketing materials. Always good to touch base to make sure you have exemptions under all the applicable securities laws.
Absolutely. And stuff like this pops up all the time in the mastermind group, in the different chats and questions asked. Sometimes it's about securities related stuff or just whatever, section of the law might pertain to our business. And a lot of it just varies so much by state that, obviously I'm not in there giving any legal advice, but it's just so common for people to ask a question. And the answer is always like, you got to talk to a lawyer in your area, in your state. Yeah. So that being said, if you wouldn't mind, could you give everyone your contact information, and then in case they want to reach out about any of the things that we've discussed, fund formation, whatever it might be?
Absolutely. So again, I'm Kimberly Mann at Shulman Rogers. My email address is kmann@shulmanrogers.com. Phone number 301-231-0957.
Excellent.
Feel free to call anytime.
For sure. We will make sure to post that contact information with the video inside the group. And yeah, thanks again. I appreciate you taking the time and being here.
All right, Kim. Pleasure. Bye-bye.